general idea of Chapter 5 is to empower public sector bodies across the EU to access data of private companies in certain circumstances. So the Commission's proposal mentions public emergencies such as pandemics, natural disasters, but also for fulfilling other public tasks like mobility planning or setting up sustainable energy infrastructure, and even if administrative costs could be reduced. But also the provisions of Chapter 5 regulate the procedure and conditions for sharing the data and regulates further details. Now, such legislation is very touchy because it concerns various interests that are involved. What stands on the opportunity side is that Chapter 5 aims to open up private data for the common good and therefore serves the societal need. But there are risks as well. So on the other side, these risks apply because if businesses are forced to share data, this can be costly and could even affect their incentives to collect data, their business models, and the involvement and functioning of data-related markets. And there's another risk, which is that if data falls in the hand of a state, it must be made sure that it is not abused by the state or by third parties. So this becomes even more peculiar if personal data is involved. Now, the big challenge for this Chapter 5 is to be designed in a way that it reconciles the common good with the market while effectively protecting the involved interests of business and data subjects. And the solutions that we find, in my view, they ultimately depend on our ideas about how data-driven markets work and how much we can eventually trust the state. Well, I think in the frame of this legislative package, it would be right to limit the scope to ad hoc data access as opposed to systematic continuous access. And this also seems to be the idea of the Commission, but I think it could be made clearer and also more consistent. How to get there? Well, 3 concrete suggestions. First, I would delete Article 15c second case, which empowers for data access also in cases where it could lead to the reduction of administrative costs, because by definition, this does not fit the rationale of ad hoc access. Second, I would clarify the scope of Article 15c case 1, which addresses cases beyond public emergencies. And this would also include to more precisely delineate its relationship with national legislation. And third, I think the legislator should better define what ad hoc access actually means. And I would suggest introducing legal presumptions, not least to prevent that the exceptional ad hoc data request would eventually turn into a rule. So I think in general, a focused and clearly targeted right poses advantages for legislation at the current stage, because it allows for better addressing the difficult relationship between the EU Data Act and national legislation, and also because compensation rules could be designed more convincingly, especially not to allow adding a profit margin as compensation, unlike the Commission's current proposal provides for. And also, limiting Chapter 5 to ad hoc requests is a first step, and starting rather narrow and focused allows us to better understand whether and how B2G data sharing actually works. And in a few years from now, the scope can be broadened and based on more solid evidence. Well, I think, to be honest, the relationship between Chapter 5 and the existing regimes for public sector data can be significantly improved. Data access under Chapter 5 enlarges the pool of public sector data, so that in general, rules on public sector data could potentially apply. And this also includes the Open Data Directive, which regulates reuse by generally accessible public sector data. Now, this directive follows the reasonable premise that wide and non-discriminatory reuse of public sector data is good, because it creates a lot of economic and societal value. Now, the provisions of Chapter 5 hold the Open Data Directive inapplicable no matter what, and this I find problematic. I can fully understand that we want to protect the rights and interests of the businesses in a way that we have to care about what happens once the state got the data. But I think we could find a smarter and reuse-friendlier way to do that, which I call a consent-based solution. Now, the idea is to ultimately let the data holder decide. If a business agrees with further reuse of its data, then there is no conflict of rights and interests. And this is why I think the law should somehow nudge towards consent of the data holder. For example, it could introduce a provision which would require the business to object to access and reuse if not wanted, without the need of further justification. Now, of course, there are limits, especially when it comes to personal data. But in general, this would not only relate to data reuse under the Open Data Directive, but also to data reuse under the Data Governance Act and access to data under EU and national access rules.